There was a paper chart on the evidence table, cheap manila. The top corner was bent, and across the front, in red block letters, someone had stamped, "No insurance." Under that, in blue ink, Dr. Elias Moreno had written, "Balance due, $0." I still see that chart when this case comes back to me. By the time it reached my bench, this was no longer only a dispute about rules. One doctor had lost his license, a town had lost its free clinic nights, and one man who ran a medical board was waiting for me to decide whether public authority had been used for the wrong reason. Subscribe to this channel. I do not say that lightly. I say it because if you are still listening at this point, you are exactly the kind of person who should hear what comes next. Subscribe. Then I will keep going. When Dr. Elias Moreno first walked into my courtroom, he did not look angry. He looked worn down in a way I have seen before, in people who have spent months defending something they never expected to lose. He carried his own file box. His lawyer offered to take it. He kept it in his hands. What stayed with me was what he noticed. While most people entering a courtroom look at me, or at the cameras outside the doors, or at the other side of the room, Elias Moreno noticed the clerk coughing behind her desk. He reached into his pocket by habit as if he might offer a lozenge. Then he remembered where he was and stopped. He was 43 years old, family medicine, Moreno Family Clinic on Birch Street in Cedar Grove, married, 2 daughters. He taught one evening class at the community college for extra money when the clinic books got thin. I did not learn who he was from a resume, though. I learned it from how he listened when other people spoke. Dr. Thomas Weller entered differently. He slowed only once he was under my eye. He set his pen down in a straight line with the edge of the table. He looked first at the press benches, then at the prosecutor, then at me. He did not look at Dr. Moreno until much later. I watch people before court begins. It does not tell me everything, but it tells me something. Thomas Weller kept adjusting his cufflinks when no one was speaking to him. When his lawyer leaned in, Weller listened without fully turning his head. And when he thought no one important was watching, his eyes went to the gallery to see who had shown up. Outside that room, he was the executive director of the Franklin State Medical Board. He had once practiced internal medicine. By the time this case reached me, he had not treated regular patients in years. He spoke often about standards, oversight, and public trust. Those words came up more than once in my courtroom. The incident, as I came to know it from testimony, emails, board records, and phone logs, began on Monday, June 17, 2024, at 8:14 a.m. at Moreno Family Clinic, 118 Birch Street, Cedar Grove. 2 board investigators arrived with a county deputy. They carried an emergency suspension order signed by Thomas Weller the night before. By 8:26 a.m., the clinic doors were locked. There were already 12 patients outside, 1 child in Spider-Man pajamas, 1 roofer with a wrapped hand, 1 older man holding insulin pens in a plastic pharmacy bag. Dr. Moreno asked if he could at least refill medicine for the people already standing there. The deputy testified that Weller's investigator said no. The order said Dr. Moreno posed an immediate danger to the public. Those 2 words matter, immediate danger. In my courtroom, I explained it plainly because most people do not know this part. A medical board can suspend a license without waiting for a full hearing only when there is a real threat that cannot wait, not bad paperwork, not a disagreement, not next week, right now. The state's evidence showed that 3 days before the suspension, the board's own physician reviewer, Dr. Ann Patel, found record-keeping issues, but no patient harm and no basis for emergency closure. At 6:07 p.m. on June 16th, Thomas Weller replied to counsel in an email and said, "Suspend him now. Let him explain himself after." I read that line more than once. The defense did not deny the email. They said it was blunt, not criminal. They said Dr. Moreno had become too loose with charting and sample medications. Some of that was true. Records were late. Donated inhalers had not all been logged the board's preferred way. A volunteer nurse had used the wrong template on a late entry. Those facts were real. Before I go further, I need you to subscribe, not as a formality, because there is one piece of evidence in this case, something small, something easy to miss, that changed the whole direction of my ruling. I want to make sure you are here when I get to it. Subscribe now. What first came across my desk was not the criminal case. It was Dr. Moreno's emergency petition asking me to stop the suspension until a real hearing could be held. What made me sit back in my chair that night was how thin the board's emergency file was. Emergency files are often rushed. They are not supposed to be empty. There is a detail most people outside court never hear. In Franklin, when a doctor is suspended on an emergency basis, the form has a box where the board must state the danger in plain words. That box exists for a reason. If the state is going to close a clinic overnight, it has to say exactly what could not wait until morning. In this case, that box had been changed. I noticed it first on a scanned exhibit. The line under immediate danger looked darker than the rest, like it had been typed in later. That was not enough by itself, but it was enough to keep me reading. By the end of the night, the licensing petition and the criminal complaint were traveling the same road toward my bench. What was unusual was not just the legal overlap. It was the human timing. Every day the clinic stayed closed. More people in Cedar Grove had nowhere to go. The county health office was overloaded by Wednesday. The nearest urgent care that took cash up front was 23 miles away. The nearest emergency room was 42 minutes in good traffic. On the first day of trial, I watched both men enter from the bench. Dr. Moreno came in through the side door with his lawyer and paused when he saw the gallery was full. Then he nodded once toward the back row. I later learned 6 of his patients were sitting there. Thomas Weller came through the main doors with only a folder in his hand. His lawyer carried the boxes. Weller looked at Moreno only once that morning. It was during the clerk's opening instructions. A quick side glance, not hatred, not fear, more like the look of a man checking whether a problem had become smaller yet. Moreno did not return it. He was reading the suspension order again, though I suspect by then he knew every line. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. Tell the stories that need to be told. The first wave of evidence established the ground: board policies, inspection photos, logs of donated medication, schedules showing Dr. Moreno's Thursday evening clinic for uninsured patients. We learned he regularly saw 26 to 34 people after normal hours. We learned he used donated antibiotics, inhalers, insulin samples, and blood pressure medication to bridge care while patients waited for county programs. We also learned where he had failed. Some notes were entered late. One refrigerator temperature log had a gap of 2 days. Some sample medications were grouped by drug instead of by patient name before distribution. I say all of that because fairness starts with saying clearly what was wrong before saying clearly what was worse. Then Dr. Ann Patel testified. She was the board reviewer whose memo started this chain. She sat very straight, kept her hands folded, and answered carefully. She said, "My recommendation was corrective action within 30 days, not emergency suspension." Then she said, "The box for immediate danger was blank when it came to me." I asked her to repeat that. She did. At that moment, the court reporter looked up from her machine. That is how quiet it got. Thomas Weller did not move much, but his thumb started rubbing the side of his pen again and again. I noticed because it was the only thing on him that had stopped being controlled. The second wave of evidence made the case larger. The defense called compliance experts who said free care does not excuse poor records. They were right. One former inspector said undocumented samples can create risk. Also right. Another said recurring after-hours clinics should have been reported in a clearer way. Again, right. Real cases are rarely clean. Then came the patients. Rosa Benitez was first, 58 years old, hotel housekeeper. She sat down, smoothed her skirt, and spoke like someone who had rehearsed only one thing, telling the truth without wasting anybody's time. She said, "He listened to my lungs before he asked my last name." It was a simple sentence. It stayed with me. After her came Marcus Hill, the roofer. type 1 diabetic, uninsured for 8 months after a layoff. He said Dr. Moreno kept him supplied with enough insulin samples to bridge him until county coverage came through. When the clinic closed, he drove 51 miles for a refill and lost a day's pay. He said, "I thought I had done something wrong by being poor." That sentence sat in the room a long time. I saw Dr. Moreno look down at the table and press 2 fingers against the edge of it, not because Marcus Hill blamed him. He did not, but because it is a hard thing to hear a grown man say that out loud in a public room. I have told this story before, to colleagues, to my family once, and every time I get to this part, I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it. The third wave began with metadata, not speeches, not tears, metadata. A board IT analyst explained that revisions to the emergency suspension form left timestamps in the system even if the printed copy looked ordinary. At 10:58 p.m. on June 16th, the form was reopened from Thomas Weller's account. At 11:17 p.m., the wording under immediate danger was added. That wording said Dr. Moreno's pattern of unregulated dispensing and undocumented treatment created an urgent and ongoing threat to public welfare. The line below it cited Dr. Patel's review as support for imminent risk, but Dr. Patel had found no such thing. That was the turn in the road. Then the state introduced emails between Weller and a lobbyist for Silver Ridge Health Partners, a private urgent care group operating 3 clinics in the county. The subject line was Birch Street. The lobbyist complained that Moreno's free clinic nights were distorting local expectations. Weller replied, "I'm aware. We're moving." I read that exchange slowly. The witness who tied it together was not a flashy witness. She was a records coordinator named Lydia Shaw, 11 years at the board, green cardigan, reading glasses she kept folding and unfolding in her hands. She testified that Weller told her not to include Dr. Patel's original memo in the press packet after the suspension. Then she said, "He told me not to make a folk hero out of a charity doctor." I asked her to repeat that too. When she did, a woman in the gallery closed her eyes and leaned back against the bench as though something inside her had given way. Weller finally looked straight at Moreno. Moreno did not look back. He was staring at the paper chart on the evidence table, the one marked "No insurance and balance due, $0." The defense argued what defense lawyers should argue. They challenged motive, memory, and interpretation. They said the Silver Ridge email was political talk, not proof of a deal. They said the folk hero comment was crude, not criminal. They said the late changes to the form were clarifying language, not false language. I considered all of it. Then Thomas Weller took the stand. He was calm, and calm can sound reasonable even when it is wrong. He said he had no hostility toward free care. He said he acted only because Dr. Moreno was practicing outside proper discipline. He said quietly, "Compassion is not compliance." I wrote it down. The prosecutor asked whether he understood that suspending Dr. Moreno would close Cedar Grove's only no-cash primary care clinic. Weller paused and said, "I did not think one small clinic would leave that many people without options." I wrote that down too. Later, trying to sound humane, he said, "I was trying to keep the peace. The paying clinics were getting restless." He said it in the soft tone people use when they want a sentence to sound practical instead of revealing. But it revealed exactly what it revealed. Subscribe if this is the kind of story you want more of. That is the whole pitch. No speech. Just subscribe if it is for you. There was one moment during his testimony when my mind reached back to my own life. I was 10 years old, sitting in a folding chair in the basement of St. Luke's Church. My mother had a dish towel pressed to her cheek because one of her teeth had cracked and we did not have money for a dentist that month. A volunteer came in with a metal tray and said, "We'll get you through the weekend." I remember the smell of bleach. I remember clove oil. I remember relief arriving before paperwork. I did not mention that in court. A judge's memory is not evidence, but I would be lying if I said cases never touch an old place in you while you are trying to do your work. By the end of closing arguments, the facts were settled in my mind. The law gave Thomas Weller wide discretion. It did not give him permission to invent emergency where none existed, alter a public record, hide an internal medical review, and use public office to punish a doctor because uninsured patients were being treated outside a billing model others preferred. On the morning I gave my verdict, my courtroom was quieter than usual, not empty, quiet. Dr. Moreno sat with both hands folded as if he were keeping them still on purpose. Weller kept looking at the water glass near his elbow and never touched it. I could hear one fluorescent light buzzing above the rear bench. I had made my decision. I had made it the night before, if I am honest. But the moment still lands differently when it is spoken out loud. I found Thomas Weller guilty of official misconduct, tampering with a public record, and unlawful retaliation through emergency licensing action. I also ordered the immediate reinstatement of Dr. Elias Moreno's medical license effective that hour. The first reaction I noticed was from Rosa Benitez. She did not clap. She did not cry out. She reached into her purse, took out her house keys, closed her fist around them, and bowed her head until her forehead touched her knuckles. Then one long breath seemed to leave the room all at once. The verdict was not the hardest part of this case for me. The sentencing was. Because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. 1 week later, I returned for sentencing. I had read the pre-sentence report, the financial statements, the letters on Weller's behalf, and the victim impact submissions. Mercy is not blindness. It is consideration after sight. I read all of it. When I spoke, I did not raise my voice. I said, Dr. Thomas Weller, I am ordering you to pay a fine of $250,000 to the Franklin County Indigent Care Trust. I am doing that because the office you used was meant to protect the public, and instead it helped close the one place many members of the public could still enter. I said, I am also ordering the suspension of your medical license for 7 years, effective today. During that time, you may not practice medicine, supervise clinical staff, sign prescriptions, serve as medical director, or sit on any licensing or disciplinary body in this state. I am doing that because you use professional authority as a weapon, and the law cannot hand that weapon back to you quickly. I said, I am further ordering 1,200 hours of community service over the next 3 years at county-free clinics and mobile care sites approved by probation. You will not treat patients there. You will do intake, records, supply runs, room cleaning, and patient escort duties. You will also complete 100 hours of ethics training focused on access to care and administrative authority. I am doing that because you need to spend time near the part of medicine you stopped seeing. Then I said, and there is one more thing. You will publish a written apology of no fewer than 1,000 words on the Medical Board's public site, in the Cedar Grove Herald, and in the Franklin Journal of Medicine. You will read that apology aloud at the next 2 board meetings. In it, you will name Dr. Elias Moreno, state that your emergency action was unsupported by the board's own physician review, and acknowledge the harm done to uninsured patients when his clinic was closed. I am doing that because public harm was carried out through public language, and part of the repair belongs there too. I was not finished. I said, you are also ordered to pay restitution in the amount of $412,680 to Dr. Elias Moreno and Moreno Family Clinic. That amount covers lost clinic income, lease penalties, staff separation costs, spoiled vaccines, records restoration, malpractice tail coverage, reinstatement fees, and reopening expenses. Of that amount, $120,000 shall be held in trust for 2 years of lab work, basic medications, and transportation vouchers for uninsured patients displaced by the closure. I am doing that because repair has to reach the people who carried the loss. Then I spoke to him plainly. I said, what you did was not a mistake in a crowded week. You took a line meant for danger and used it for dislike. You closed a clinic on a Monday morning and made working people drive across county lines for insulin, inhalers, blood pressure checks, and strep tests. You cost Dr. Moreno his practice for months, his staff, his lease, and the trust of patients who already walked through his door embarrassed to ask for help. Then I said, your wife and your sons did not sign those orders. They do not stand convicted here. But they will live beside what you chose, and I am aware of that. Privilege in medicine is not a reward for status. It is a duty to do less harm than you have the ability to do. I believe you forgot that. I do not. Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here. After sentencing, I remained on the bench while the paperwork was finished. That is when I saw Dr. Moreno stand up slowly, as if his body had not yet been told the waiting part was over. Rosa Benitez reached him first. She touched his sleeve and said, "Wednesday mornings again?" He nodded once and said, "Wednesday mornings again." Across the room, Thomas Weller stayed seated longer than most defendants do. His lawyer said something to him that I could not hear. He answered without looking up. Lydia Shaw walked past him on her way out and never turned her head. The room felt less like triumph than like a heavy object had finally been set down. The appeal was filed 31 days later. The Franklin Court of Appeals, 2nd District, heard it the following spring and affirmed in full. The opinion said emergency licensing power does not become lawful because it is dressed in administrative language. It took 11 months from notice of appeal to decision. I was not surprised, but I was relieved. What happened next is the part people ask me about most. On September 8, 2025, Moreno Family Clinic reopened on Birch Street. I did not attend. Judges should know where not to place themselves. But I received a note through proper channels from Dr. Moreno's lawyer. It said the first patient that morning was Marcus Hill, the roofer, and the first chart opened at 8:03 a.m. had the same red stamp on it, "No insurance." 3 weeks later, driving home, I passed the county mobile clinic parked behind a middle school gym. I recognized Thomas Weller before I was fully sure because of the way he stood, straight-backed even while carrying weight. He was in a gray polo with an ID clipped to his belt, lifting boxes of intake forms from a van to a folding table. No one there seemed interested in who he used to be. They were busy. So was he. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. The question this case left me with is not whether rules matter. They do. I know very well what happens when medicine has none. The question is this: when did so many people in positions of care start mistaking the system for the people it was built to serve? I still do not have a clean answer. What I learned is smaller than an answer and harder to turn into a speech. Harm does not always arrive shouting. Sometimes it arrives typed into the proper form, signed at the proper hour, spoken in a calm voice, carried out by people who still think of themselves as responsible. If you have ever sat in an exam room rehearsing how to say, before anything else, that you do not have insurance, then you know the face I recognized in my courtroom. The shoulders already apologizing, the eyes trying to figure out whether help will still be there after the money part is said out loud. I saw that face in Cedar Grove. I know what it costs. And if you are someone with authority over doors, licenses, schedules, budgets, or forms, then here is the question I wanted to ask Thomas Weller and could not ask from the bench. When the person in front of you cannot pay, what exactly are you protecting if the answer is not them? Spend one morning at intake. Watch who comes in. Listen before you sort. Start there. I keep returning to that paper chart. Cheap Manila, bent corner, no insurance in red. Balance due, 0.0 in blue ink. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. The comments are where people who care about the same things tend to find each other.